UK, USA, Tax Talk and More from Collyer Bristow. Welcome to the Collyer Bristow series UK, USA, brought to you by our tax and estate planning team. During the series, we'll be discussing a range of tax topics, all with a US flavour. In this first episode, Crossing the Pond, Senior Associate Aidan Grant is joined by Senior Associate Charlie Fowler to discuss tax and immigration issues that US citizens looking to come to the UK might need to consider. We hope you enjoy the episode.
Hi there, my name's Aidan Grant. I'm a Senior Associate here in the Tax and Estate Planning team at Collyer Bristow. I'm joined today by my colleague Charlie Fowler, who is also a Senior Associate in our Tax and Estate Planning team. Just a quick word about my background. Here at Collyer Bristow, I advise high net worth individuals on a broad range of tax and estate planning matters, including domestic and offshore taxation, trusts, wills, lifetime estate planning, and so on. I also sit as a member of our charities team, advising both charities and their trustees on a range of charitable matters. However, for the purposes here for this podcast, one of my key focuses in my work is on advising individuals and their families who have US-UK tax nexuses, and so helping to navigate the UK tax landscape with an eye on the US rules and how to avoid the worst of the US pitfalls. Charlie, perhaps you'd like to introduce yourself as well.
Thanks, Aidan. Morning, everyone. Yes, I am Charlie, and like Aidan said, I work with him in the tax and estate planning team, but I have two hats, really. I have my tax hat, and I also have my immigration hat, so I head up the firm's immigration practice, and we advise individuals and families and businesses on most immigration matters that are relevant to our clients.
Wonderful. What we are going to be discussing today is, in our inaugural episode, is looking at the tax and immigration issues that Americans might need to think about before they come to the UK, and sort of some tax tips for once they're here. We'll talk about a number of different immigration issues and the various visas that individuals can apply to come to the UK on, looking at some of the planning steps that individuals might like to take beforehand to ensure that sort of any tax they incur in the UK is kept to as minimal or as efficient a level as possible, whilst also balancing sort of administrative inconvenience. And then finally, turning our attention to what UK resident non-domiciliaries, as we refer to them, need to think about while they are here, and what the various sort of tax options are available to them. If that sounds like a lot, we will try and keep it as brief and enjoyable and entertaining as we can possibly make tax. And hopefully there'll be a few tidbits at the end, a few takeaway points for those that managed to make it through to the end. So on that basis, it's probably helpful to introduce you to a hypothetical client that we can hang the tax and the immigration advice on. Let's call him Mr. Smith. Mr. Smith is a US citizen resident and domiciliary, so he's sort of wholly US based. He has no prior connection to the UK. But let's say he's looking to move to the UK in the next year or so, and he's thinking about what he needs to know now beforehand before he makes that trip. Let's give him a nice round $10 million to his name, and let's say that he has a mixture of sort of liquid and illiquid US assets. He's coming to the UK perhaps broadly for work purposes, but what that work is, we will discuss with Charlie shortly. Additionally, he's thinking about whether he could bring his wife and his children, all of whom are US citizens as well, along with him for the journey, and what are the things he needs to think about for his family. And then just finally, let's say, just putting some parameters on that scenario, let's say that they might be here for 5 years, perhaps 10 years. They're not looking to come for a summer, and they're not looking to spend the rest of their lives here. It's a short business trip for a period of years, and I imagine his kids will probably be in school for that time as well, and then they probably eventually return to the US. So, how does that all sound, Charlie? Anything I've missed?
No, that sounded fairly comprehensive to me.
Right. So, in the words of Julie Andrews, let's start at the very beginning. I'll try and keep jokes to a minimum in this podcast. When we're looking at the immigration issues that someone needs to think about before they arrive in the UK, I as a non-immigration lawyer, only sort of understand the very broad issues at stake. But I presume, Charlie, the first thing to think about is what are the different ways that someone can legally travel to and stay in the UK, sort of from a sort of a visa perspective. What does Mr. and Mrs. Smith and their children need to think about?
I suppose I have to answer that with a very loyally start, which is it depends. It depends on what it is that Mr. Smith and his family want to do. Taking Mr. Smith, if he wants to go back to school, he could apply for a student visa. And provided that student visa is at a postgraduate level or above, he could bring his family with him. But I'm assuming for these purposes that he's past that stage in life and is looking slightly different visa route. You mentioned that he might want to come to the UK for business reasons, and there are various immigration categories that will allow him to set up a business here in the UK. I mean, I can come and to discuss some of those in the future, but there's things called the startup or your innovative visa, which are pretty much geared to allow someone to come to the UK to set up a business here, and there are various requirements that attach to those visas. There's something called the representative of an overseas business visa, which is where someone working in a senior position in an overseas business, in this case in the US, comes to the UK specifically for the purpose of setting up that overseas business, their first trading operational presence here in the UK. And then finally, there's perhaps also in terms of the more appropriate visa category, there's something called the investor visa. This isn't specifically a work visa, but it has quite a lot of flexibility and it would allow Mr. Smith to come here if he wanted to and set up business in the UK. But it might be, for example, that he is already working for or is looking for employment, in which case there are different types of work visa that might apply to him as well. I mean, even if he wanted to get his fingernails dirty, he could apply for a 6-month seasonal worker visa working on a farm picking strawberries. But speaking of someone that did do that, in fact, it was raspberries in my case, quite a lot when I was younger, but I'm assuming that's not what Mr. Smith and his family are wanting to do. But one thing that perhaps might be appropriate is one of those that I mentioned, that is the investor visa, because it has a bit more flexibility and it gives Mr. Smith and his family quite a degree of freedom. Because the other visa categories I mentioned for setting up a business, for example, the innovator visa, the startup visa, and to some degree the representative of an overseas business visa, they're quite not restrictive, but there are quite specific requirements that apply to the business that Mr. Smith would need to be set up. That is, the business has to be new, it has to be innovative, it has to bring something different to the market. He has to have the relevant skills. In some cases, he has to have funds to invest. There has to be potential for job creation, the potential to expand into domestic, international markets. With your investor visa, none of that applies. He can come up and set up a business, whatever he wants to do, and there he is, and he can do it.
Presumably, and this is why immigration and tax often go so hand in hand, where an individual is looking to come to the UK to start their own business, as opposed to let's put aside the sort of the secondment question for the time being, but let's put aside the investor visa, because it sounds like this is what we would be sort of recommending for this individual as a potential option. But just thinking about that whole setting up a business or importing a business over to the UK that is owned or controlled by Mr. Smith, there are, of course, sort of tax issues that come with that can't be considered in any form in isolation to the immigration rules. You and I both know from our experience as tax lawyers that if you are the director of an overseas company and you come to the UK and become a UK resident director, that can, in certain circumstances, depending on the nature of the administration of that company, cause that company to become a UK tax resident, and it can expose that company to UK corporation tax, for example. Or you can end up with a branch or an office, in essence, in the UK, which can have that consequence. I mean, from the US side, I'm familiar with the issue of control foreign corporations. So if that American comes to the UK and sets up a business in the UK and as a UK company, the risk of that company being considered a CFC, if it's controlled and managed by an American citizen overseas, is very high, and the tax on that can be quite punitive. So this is why we thought that immigration and tax should be something to be looked at the beginning, but also looked at in collaboration, because it's important that referrers, clients, individuals know that these sorts of discussions always need to be very holistic and not be sort of taken in isolation.
Yes, you're exactly right. And as ever, the most sort of lead-in that we can have in these matters, then the sort of the greater guns we can bring to bear. That is, the more value we can bring to do this. And you're exactly right. Where Mr. Smith, it might be that he's looking to bring a business to the UK, or that he has businesses overseas. It might be that he's involved in different enterprises and has different business assets, not just in the US, but around the world. And part of the planning is not just to say, well, how can I get here? It's what is the effect of my being here, not just on me and my family, but on, and not just on my global assets, but also my global business interest at the same time. You and I both advise many clients, and as part of their pre-arrival planning, we look at those business interests. It might be that they're happy to discontinue their sort of more active involvement in those businesses when they're in the UK. Or it might be that they do want to continue to have some degree of involvement, in which case we look at ways in which that involvement can continue, but where we avoid the situation you touched on before, where the central management and control of that business can be taken to be carried out from the UK, with the detrimental tax effects that will have when they do that. So, as you say, yes, the word holistic is used a lot. It's not always my favorite word, but yeah, it just means it's a fully rounded approach. And that's the advantage at Collyer Bristow, where almost under the same departmental, not just a firm roof, we can offer both the immigration services and the tax services, and we can spot issues before they even arise for clients, so that they can make sure that they're in the best position, not just when they arrive, but before they even get on the plane.
UK, USA, tax talk and more from Collyer Bristow.
There are a number of different issues that someone has to think about before they come to the UK, and clearly the focus for the time being between us here on this episode is to do with tax. But there are sort of practical concerns that will arise for people looking to come to the UK. And before we sort of turn to what an investor visa is and what requirements Mr. Smith has to hit, I think there's two things I imagine any immigrant to the UK has had to think about in the last couple of years. One is, what does that mean for Mr. Smith's family? And I presume, based on my scant knowledge of immigration law, that the family can come with Mr. Smith under his own umbrella. And then secondly, I know everyone's probably sick to the back.
Now you make me think it's like Mary Poppins now flying over.
we've had Julie Andrews once already. We can have a Julie Andrews podcast separately if you want. And then secondly, raising the spectre of Brexit again is perhaps you might just touch on, if, let's say, for example, Mr. Smith's wife was a French citizen, for example. Now we are in a post-Brexit world. Really, to what extent does Mrs. Smith's French citizenship help her at all? If you could touch on those, perhaps one after the other, the family, and then
absolutely. So the first thing, when we talk about family members, yes, broadly, family members can, in many visa categories, join, or come at the same time, or join the main applicant in the UK. And by family member, broadly, you're looking at spouse or civil partner, or someone living in certain circumstances with the applicant as their spouse or civil partner, so cohabitees in certain circumstances, and their children under 18. So if the children are over 18, then they might struggle. And if they are not lineal descendants or spouses, they might also struggle to join as family members in the UK. But the broad position is that most, in fact, all of the visa categories I mentioned before, including the student visa, if it's at the relevant level, are categories where the main applicant can bring their family with them. And when they extend the visa, the family can extend. And if they apply for permanent residence, the family can, under many circumstances, apply for permanent residence at the same time. In terms of Brexit, you're right. We're in the post-Brexit world, and what that means now is that there's a diminishing window for people with family members who are EU citizens to use that EU nationality to their benefit in coming to the UK. That is, an EU citizen who has some form of presence or footprint in the UK before the end of the transition period, that is, before the 1st of January 2021, would be allowed, or in certain circumstances can apply for something called settled status or pre-settled status under this scheme called the EU settlement scheme. And what that broadly allows them to do, if they apply successfully, is to live and to work in the UK, what's called exercising their treaty rights in effect, including studying, largely as if Brexit hadn't happened. And that is also applies to their family members. So looking at Mrs. Smith in this example, if she were a French citizen and if she and the family had been in the UK before 1st of January, they could have even arrived on the 30th of December, the 31st of December, and got a stamp in their passport to prove it.
As some of your clients did.
As some of their clients were certainly advised that they might want to, then they could apply, or Mrs. Smith and the family could apply under this settlement scheme and give them the right to work and to live in the UK without requiring the visas that I've mentioned before. So in fact, the deadline for applying under the settlement scheme is the end of June this year to do so. So if that applies, Mrs. Smith can apply as a French citizen, and Mr. Smith and the kiddies can apply as the family members of a French citizen. So like I say, there's that sort of diminishing window for them to do that now. But that ship will have sailed if they weren't in the UK before the 1st of January, and it'll be long over the horizon if they don't apply before the end of June.
That makes a lot of sense. And that was why all the Brexit wrangling was happening when it was.
Exactly.
I guess the only other thing, just to touch on in this area before sort of turning to the investor visa in particular and how this sort of starts to play into some tax considerations, is just to say, for the avoidance of doubt, and I know we as lawyers like to throw in a caveat, that of course, if in fact Mrs. Smith were not a French citizen, but she were a UK citizen, then she would have the right to return here as a UK passport holder. But from a tax perspective, both Charlie and I know that in 2017, new rules were introduced that can quite harshly tax what we sometimes refer to colloquially as returning domiciliaries to the UK, which are people who were sort of born in the UK with a UK domicile of origin, who emigrate abroad and acquire a new domicile, let's say here for these purposes, a US domicile, and then later return to the UK, become tax resident again. I mean, we're not going to go into this on this podcast. We may well turn to this at a later podcast, but it is just to say at this stage that if anyone listening to this episode is thinking of returning to the UK and happens to hold a UK passport, then it may be necessary to just take a bit of a closer look at the circumstances around the acquisition of that UK passport and whether that individual would fall into these slightly more punitive tax rules. Do you agree, Charlie?
Absolutely. Yeah, absolutely. So the tax benefits which non-UK domiciliaries can enjoy are to some degree perhaps almost completely eroded if you are, as you said, a returning domiciliary. And we have clients who've been affected by that. We have one interesting client who met her husband who was working for the US Air Force during the war. She was British, he was American. They lived in America for 40, 50 years, but on returning to the UK, she was in a very different position than he was because she was a returning UK domiciliary. It's something you have to bear in mind, and there's a relatively new bear trap that the unwary and the ill or not at all advised can fall into.
Absolutely. So having considered the various options, let's just assume Mr. Smith has decided an investor visa, this investor visa that you've referred to sounds like the most sensible idea. What are some of the things he needs to know about what he's investing in, how much he's investing in, and then we can sort of use that to start to think about what are some of the steps he needs to take with his finances before he comes here, what we sometimes in the business refer to as sort of pre-immigration planning. So how does investor visa work?
It's relatively straightforward in the sense that I can boil it down to really two requirements. Number one, Mr. Smith will need to have a minimum of £2 million freely available to invest in qualifying UK businesses. And by that, I mean broadly active trading businesses in the UK. Those kind of investments that he would in the future have to make is investing in share capital, loan capital in those qualifying businesses. But for the purpose of making the application, he just needs to show that he has those funds freely available to transfer to the UK.
So he doesn't have to actually invest the funds, he just has to have them freely available.
Correct. You can have invested them up to 12 months before you make your application, but broadly, many and most clients do it after the event. They don't want to invest funds in the UK and create a UK tax headache unnecessarily if, for whatever reason, their visa is rejected. Not that I've ever had an investor visa rejected, but mostly you have to show that you have the funds available. And then the second requirement that I mentioned is you have to have an account open with a UK financial institution for the purpose of then investing their funds, probably within 90 days, should your visa be granted. And that is kind of it.
Is there a period of time that you have to have those funds invested for, or is it your visa lasts for so long as you have those funds invested, and if you decide to withdraw your investment, your visa is withdrawn at the same time?
Largely, yes. I mean, you have to, it's more a question of when you come to extend your visa. So the initial term is 3 years, or possibly 3 years and 4 months, actually. And then when you come to extend it, you have to show that you've met the requirements applying to your investments throughout that 3-year period. You don't, if you decide you don't want to do it anymore, or you haven't kept up with the rules, when you won't be able to extend your visa, and then your time in the UK will be curtailed in effect.
I guess the only other question I have about the investor visa, and this is me scratching around in my brain for sort of updates from a few years ago, was it not the case that there was a second category of investor visa for those investing greater funds in the UK? Am I forgetting something, or have those been scrapped?
No, you're right. So it's all within the same category of visa. They're all investor visas. But if you invest a larger amount, and you're right, there were changes in March 2019, whereby you can no longer invest in UK gilts. It has to be sort of active trading UK companies. But if you invest a larger amount, 5 or 10 million pounds, you can be eligible and apply for indefinite leave to remain, permanent residence to you and me, after 2 years, which can mean that if you qualify, you no longer have to have your funds invested, and you can, if you want, take them offshore again and take away a UK tax headache you don't need to have, or you can retain the money onshore if you want to use there. But you're right, the more you invest, the quicker you can be eligible for permanent residence.
Kelsa Priest from the UK government.
Yes.
So I guess is our takeaway to all the billionaires that are listening to Mr. Musk, Mr. Bezos, Mr. Gates, if they are thinking of coming to the UK and they're thinking of how many zeros to put on the end of their investment, then adding an extra zero might make their life slightly easier. I'm sure the UK government would also be absolutely thrilled with the investment, but it's not just a case of investing an amount, but there is a ratcheting effect to a degree.
Yeah. Yeah, if they forget to count the number of zeros when they sign their check, then they could find themselves eligible for permanent residence sooner than they might have thought. Yes.
Yeah. Don't you hate it when you miscount all your zeros in your bank account?
Hard to miscount when there's only 2 of them.
Yeah. So let's assume then that Mr. Smith is looking to bring, let's call it his £2 million sterling. Of course, I mentioned previously that he was worth $10 million US dollars, so he'll have to do some conversions. But let's say he's now trying to identify what it is that he and his family might need here in the UK over the next let's call it 5 years. Let's give him a shorter stay in the UK. To my mind, as the tax lawyer, I'm already thinking about certain topics that we can discuss perhaps in a little bit. But with respect to that £2 million, what's the tax treatment going to be on that £2 million when he brings it into the UK? Or are you going to tell me that actually it's the same tax treatment as for the remaining $8 or so million that he has, and so we should just consider them all in the round? Well,
again, it depends. So it depends when he brings them into the UK. I mean, we're probably not going to go into huge detail on this podcast, but there can be a difference about when you bring money to the UK depending on whether or not you're resident here. And largely, if as a non-resident you bring money into the UK, you don't face the same tax penalties that might arise as if you bring certain funds in when you are a UK resident. And so, I mean, if clients can bring the funds onshore before they become UK resident here, then there are no tax implications for doing so. We have a number of clients, for example, who've successfully applied for investor visas recently, and a couple of them bought the funds onshore in March and are going to become UK resident this tax year. And then, but because in March is the previous tax year, there's no tax implications for them when they bring the money onshore, because they're not at that point UK tax residents. So if they can do it at the correct time, there's no tax effects of having done so.
Which I suppose brings to mind the one bit of salient advice that we hope every client would take away from listening to this conversation, but probably every advisor would say to them, which is coming to your advisor before you want to carry out your planning is much preferable to calling up your advisor once the plane has landed at Heathrow saying, "Oh, what do I do now?" To the extent that an individual can give an advisor a full tax year, and we'll come on to tax years in a second, but to the extent you can give an advisor a full tax year in advance of your arrival, then that's ideal, because it means that we can carry out planning knowing we're not going to be doing it in the year in which the person comes resident the first time.
Absolutely. And yes, the more time we have, the better. And yes, we can do it towards the end of the tax year. But, if we want to have a nice, gentle March and a relaxing Easter, then preferably we find out about the planning sooner rather than later. Yes. And actually, just before we go on, just one last point about investor visas, because we talked about them in the context of coming to the UK to set up a business. One advantage of the investor visa is that you don't have to do anything if you don't want to. I mean, you can come here to work, you can come here to set up a business, you can come here to study if you wanted to do that, or you can not work, not study. You don't even really have to live in the UK. Some clients, including US clients, remain US resident and use an investor visa, if you like, as their open door to the UK to come and go as they please. You won't be able to apply for permanent residence if you don't spend sufficient time in the UK. You just have to keep on reapplying, or rather extending your visa period periodically. But it gives you the freedom to do as much or as little, or spend as much time or as little time in the UK as you want. That's the last thing I would say, really.
UK, USA. Tax Talk and More from Collyer Bristow.
So let's say Mr. Smith has decided he's going to come to the UK and he set aside his £2 million for his investor visa. And now he's just thinking more broad about what are the things he needs to know, even at the most sort of high conceptual level. I think there's a couple of things that we need to make sure we mention to him, Charlie. One is talking about how does tax residency work in its broadest sense? And again, that's very much a discussion for another topic, but I think we can sort of offer some tidbits of advice here. When does the tax year start? When will he be resident? What are the rules by which he'll be resident? And then we can sort of mention what planning he might want to take in advance of whatever that date is that he's going to be resident for the first time. So as far as residency is concerned, there's an important distinction that every American needs to be aware of when it comes to the US and the UK tax rules, and which underpins a lot of is a fine example of the differences in the way that the US and the UK tax their citizens and UK residents get taxed here in the UK. And that is that the UK tax year starts on the 6th of April each year. The US tax year starts and ends on a calendar year basis. And so when we are talking about the residency of an individual here in the UK, we are talking about a strictly tax year treatment. And any time that you hear Charlie or me talk about tax years, we're talking about UK tax years here. So your client, you mentioned there, Charlie, where you had clients looking to bring their investments in and they were doing them in March in anticipation of the next tax year. That is because the tax year ended 5th April in the particular year in question is a wholly separate tax year, even if they ended up coming to the UK, but 2 months later, let's say.
Yes, you're exactly right. The 6th of April, the start of the new tax year, is when you turn over the new tax leaf, if I can use that expression. So anything done before then in a previous tax year is viewed differently it is treated differently from what happens after that 6th of April point.
This is where the American advice and the UK advice need to get dovetailed very carefully, because, of course, if they're carrying out any planning in March with a view to then doing something in a separate tax year in April, that will, of course, all take place in the same US tax year. And so we want to make sure that matters are not done inadvertently in something that might be counted as a previous US tax year, despite the fact that it's the same UK tax year, or vice versa. So, I mean, as an absolute broad brush approach to residency in the UK is governed by something called the statutory residency test, which came into effect on the 6th of April 2013. And so we're only really considering the rules in the last 8 or so years. Residency starts and finishes on a tax year basis in most cases. And so if Mr. Smith comes here, let's say in June, or he decides to come in the warm summer months, although he arrives here on, let's call it the 1st of June, he can in fact have his residency backdated for tax purposes to the 6th of April. We can come on to whether he can get around that, but it's important for an American, or indeed any immigrant here to the UK, to know that unless they take active steps to claim what's called a split year treatment, they will be deemed to be tax resident for the entire tax year if their presence in the UK in that tax year is sufficient for them to trigger the residency rules. And those rules are, in essence, a series of automatic tests that say if you meet one of these rules, you will automatically be considered UK resident, or indeed not UK resident, the most common one of which is, have you been living in the UK for half plus one of the number of days in the UK tax year, 182 days. If you have, you'll be resident here. If you've been resident here for less than half of the year, then that individual can still be resident here under what's known as the sufficient ties test, which is broadly an assessment of the number of connections or ties that an individual has to the UK, and then the number of ties give rise to the number of days that you can spend here. That number of days could be 120, 90, 45. It really depends, but we would always encourage individuals to seek out advice from us first, wouldn't we, Charlie?
Yes, it's one of those things whereby careful planning can save a lot of trouble down the line. And by careful planning, I can sometimes really literally mean keeping a careful note in the planner, in your calendar, in your diary of when you're in the UK, creating that evidential, I guess, body of evidence really, so you can demonstrate if you need to in the future when you've been in the UK. And sometimes it can come down, we both had it, to a matter of days, whether or not a person has spent sufficient time in the UK to become either advertently, hopefully, or certainly not inadvertently, UK resident.
And tying it together to the point you made previously, that is how it is that an individual could come to the UK and spend some time in the UK without becoming resident for the first time. Because if their allocated number of days under the sufficient ties test is, let's say, 90 days, and they come to the UK for 2 months in the summer to enjoy, a bit of shopping in the West End, a few trips to the theatre and such, those 2 months will not be enough to trigger residency because they've not met the number of days under the sufficient ties test. So the time that an individual is looking to come to the UK is not necessarily the date from which they are tax resident. Indeed, it's worth pointing out that if they want to come to the UK in, let's say, February, and then remain for the remainder of the tax year, it's entirely possible that they won't have enough days left in the tax year to be treated as residents anyway.
Absolutely. I mean, you don't have to make sure that your flight arrives at 9 a.m. on the 6th of April in order to prevent yourself becoming resident. I mean, there's some degree of flexibility there whereby you can spend time in the UK in the year before you actually become tax resident here.
Although, of course, if you can arrive at 9 a.m. on the 6th of April,
we're very happy.
Yeah. I have a client whose birthday is the 5th of April, and that is almost the opposite effect, because it means that every birthday they have 1 day in that tax year. If only they could have been born on the 6th of April, it would have made everything so much easier when they turned 18 and various things happened to them. So now we know when Mr. Smith and his family are going to be resident here. Let's think about a couple of just really useful tips that any individual coming to the UK, but particularly Americans coming to the UK, need to think about as regards their personal finances and avoiding any kind of inadvertent tax pitfalls on touching down here in the UK. And to signpost those for the listener here, Charlie and I are going to broadly think about two important topics, one of which we've already touched on already, and that is reviewing an individual's directorships and whether, if this person is a businessman, he has any companies that he owns or controls and the consequences there. And then secondly, thinking about isolating and separating out a pot of money or some funds that he can then use to live on in the UK in a tax-efficient manner so that he's not incurring tax as and when he brings funds into the UK. Turning to that first question first, this issue of directorships, we already touched on this, but we sort of want to reiterate it again. It's the issue around what's known as central management and control in the UK, which is a body of UK case law that's arisen governing the extent to which a company, a foreign company, should in fact be considered UK tax resident. And it all goes to whether any given individual is UK resident and where that sort of effective management control is, Charlie, isn't it?
Exactly, because there can be implications for the company if it is treated as being managed and controlled from the UK. There can be income tax implications for a UK resident director of that company, even if they're not actually a director, but they're what's called a shadow director, so that they carry out actions which are akin to or which lead to them being treated as a director of that company. And as we touched on before, when they're coming to the UK, we would speak to Mr. Smith and his family and try to understand what commercial business interests they have and the extent to which there is a risk of central management and control being treated as carried out from the UK when they then move here.
And tying that to the US concerns, companies are used for estate planning reasons in the US in a way that they're not necessarily used in the UK. And so it's conceivable that there may be LLCs, S-corps, and other corporate structures that are used for perfectly good and efficient US tax planning purposes that need to be reviewed in light of someone's emigration to the UK, immigration from our perspective, because it may be that although a particular corporation in the US has, let's say, checked the box and is an now a look-through for US tax purposes, we may not well consider that the same. And the last thing you want to do is to give your US UK accountant a headache because you have a look-through entity in the US that's taxed on the ultimate shareholder, for example, but a company that, because the director is now a UK resident individual, is treated for UK purposes as tax resident here, and we will tax as a separate corporation in its own right. And so these are all issues that we simply raise without necessarily offering the concrete advice to, because the correct and the most appropriate decision will depend on the client in question. But just raising these as issues that people need to know about beforehand, because it may be that a degree of unwinding needs to take place, or at the very least making sure that an individual is coming to the UK with their eyes wide open, so that if they fall in that pitfall, they know they're falling into it.
Yeah, exactly. And it's not to say, of course, that they have to surrender and give up and any of those commercial interests or to stop participating and being involved in those businesses. There are planning steps we can put in place to make sure that they can still remain involved. They can still, for example, act as directors if they need to be, without, or at least with putting the best sort of processes in place to mean that they don't fall foul of these rules. So it's not to say that you have to divest yourself of all of your commercial engagements and enterprises. It's more that you just have to be aware of it and ideally discuss it with us beforehand, exactly as you say, Aidan. So you go in with eyes wide open and you can put yourself in the best position for you and your family when you move here.
UK, USA, tax talk and more from Collyer Bristow.
So turning to the second of the two pre-immigration tax planning ideas we mentioned, I'd said Mr. Smith might want to think about what funds he makes available or separates and isolates and puts to one side, so that when he and his family are here in the UK, he has a pot that he can draw on tax efficiently. This then brings to question the important distinction of how an individual is subject to income taxes, by which I mean sort of UK income tax and capital gains tax, once they are UK resident. Broadly speaking, an individual can be taxed in the UK in one of two methods. And I give these very high-level explanations because these are very complex things and people make their entire livings dealing with the minutiae of these. By default, a UK resident is taxed on their worldwide income and gains as they arise, and for that reason we refer to this as the arising basis of taxation. But if an individual, like for example Mr. and Mrs. Smith in our scenario, if an individual comes to the UK and is resident here but is neither UK domiciled nor deemed domiciled here, what we refer to as a resident domiciliary or a non-dom, sometimes referred to in the press, then that individual has the option to elect to be taxed on what's known as the remittance basis of taxation, whereby, broadly speaking, they still pay tax on an arising basis here in the UK on their UK source income and gains, but they don't pay tax on their foreign source income and gains unless and until they, what we refer to as remit those funds to the UK, by which I mean they bring those funds into the UK or otherwise spend them in the UK. So, settling a credit card for UK expenditure out of a foreign bank account or liquidating an account and bringing the cash proceeds into the UK would be remitting foreign gains. But otherwise, if those foreign gains aren't remitted, then they get shielded from UK tax until that future point when those funds are remitted. How does that sound as a breakdown of the arising basis and remittance basis, Charlie?
It sounds excellent to me, Aidan. And you're right. There are minutiae of this which you can do a whole sort of 24 series of podcasts just discussing in the same way as you can for remittances. There were various rules about what does and does not constitute a remittance if either you, the taxpayer, bring money to the UK or certain persons connected with you. And we could spend many, many hours doing that. But I think for our sanity and those of our listeners, we'll park that for now.
Yeah. But this is where the arbitrage between the US and the UK systems becomes particularly delicate. And I think this is where we come towards, as we approach the sort of the back end of this podcast episode, some of the real interesting tidbits for those listeners that have made it this far. And that's looking at whether actually the remittance basis of taxation is in fact advantageous for Americans here in the UK. Because on the face of it, and without an eye on the American system of taxation, it usually seems to be fairly inarguable that the remittance basis of taxation can be and is in fact preferable for resident non-domiciliaries living here in the UK, because why pay tax on your foreign income and gains unless and until you need them here in the UK? There is little downside on a pure UK tax basis from claiming the remittance basis if you can, and indeed for the first 7 years that you live here, that the remittance basis is free to access. There's an annual charge starting at £30,000 that you have to pay once you have been here for 7 years. But most tax advisors looking purely at the UK tax system will tell you, yes, the remittance basis is something that you should consider very strongly. Where it becomes problematic for Americans is that, of course, that American is already subject, and by American, I'm referring to an American citizen for convenience here, is already taxed to US income tax on their worldwide income and gains already. And so when considering the remittance basis and the opportunity to shield foreign income and gains, by which I mean non-UK income and gains from UK tax, there has to be put in the context of the fact that that individual has probably already paid US tax on those same income and gains. Tax which in the US and in the UK are taxed on broadly the same tax rates. I mean, presently, the US tax rate is hovering around the high 30s. I noticed Mr. Biden recently announced that he was thinking of raising the tax rate, but from, I think it was 37% to 39.6% or something. But, is broadly commensurate with our tax rate of up to 45%. And the taxation on capital gains, currently, as at the date of recording, is still fairly simple, knocking around the low 20s. So if that individual is already paying tax in the US, there is an argument that it makes sense for that UK person to be taxed on the arising basis on their foreign income and gains as well, suffer the UK tax at broadly the same tax rate, claim a tax credit for the tax paid in the US here in the UK or vice versa, and then have the opportunity to remit those funds entirely tax-free to the UK at a later date, compared to the scenario where an American is a remittance basis payer, pays their US tax in year one at US tax rates, in year 3 or 4 when they want to bring that money to the UK, remit that money to the UK, but because they're a remittance basis taxpayer, they then suffer UK tax all over again. You have a mismatch in the timing of those two taxes, and then there's no credit available, and lo and behold, you've got a double tax charge, which is, I've not yet met a client who's prepared to suffer a double tax charge. Much better to consider, let's say for the sake of income, pay your UK income tax at up to 45%, having already paid your US income tax at, let's call it 39%, that additional 5% income tax, 6% income tax, it's for every client to determine, but there is a good argument that it is worth paying that additional 5% for the freedom of being able to decide when you bring that money to the UK in the future. Indeed, there's only really two scenarios where I think a remittance basis form of taxation is really useful, and that is where the individual is so wealthy that 6% tax does make a difference, and they're prepared to take the risk because, if they're incurring many hundreds of thousands of pounds of gains each year overseas, then that 6% tax is not insignificant. But secondly, if that individual is absolutely sure they're not going to need that money here in the UK, because, for example, let's take the example of Mr. Smith to bring it all together, his UK salary is going to be more than enough to support him and his wife and his children. They don't need that money from the US, so sure, keep it overseas and shield that money from UK tax. Just support yourself on your UK taxed funds from the off. On that basis, the arising basis is usually quite preferable to most sort of everyday Americans coming here to the UK, or certainly any American, who isn't incurring hundreds of thousands of pounds of tax each year. However, there are circumstances where remittance basis tax is still a useful form of taxation, and there are some planning opportunities that we recommend for remittance basis taxpayers in advance of them becoming UK resident, aren't there, Charlie?
Yeah, absolutely, and it's just worth bearing in mind that obviously there's no sort of one size fits all approach for clients, and sometimes it's a maths equation about looking at their assets, looking at those that might generate income and gains when they're in the UK, and then determining what the best strategy is. It's also worth bearing in mind from an investor visa point of view, looking at Mr. Smith, is that if he brings let's say he goes down the investor visa route and brings £2 million to the UK for the purposes of investing in the qualifying investments. If he does it at the right time, that will be a tax-free transfer of funds to the UK. If after a period of time he then is able to apply for indefinite leave to remain for permanent residence, he would no longer need to have those funds invested in the UK. And actually, he can take those funds out, and he has, in this case, £2 million perhaps of what is now clean capital for him to use in the UK. He's been able to get quite a substantial sum in the UK, potentially tax-free, once he's then qualified for permanent residence. So it's just another thing to bear in mind, that actually you can have this kind of windfall at the appropriate time once you've qualified for permanent residence.
That's very true, and one should never sniff at £2 million of clean capital. Of course, the flip side of that, the one tax I don't think we have yet discussed is inheritance tax. Of course, if he has those funds in the UK and wants to keep those funds in the UK, then he runs the risk there's going to be inheritance tax on them.
Exactly. I mean, we normally say to clients, if they would like to, they can insure the risk. I mean, even if they're only intending to have the funds invested for a small number of years, they can get term life insurance fairly cheaply to insure against that risk. But you're right, even with £2 million invested, you've got a potential £800,000 inheritance tax headache at the time. But that's why when clients move to the UK, not just pre-arrival planning, but post-arrival planning as well, when they acquire assets in the UK, that's accompanied by UK planning, often as simple as having a will, a UK will solely in respect of your UK assets, most commonly leaving everything to your spouse. So in the event that Mr. Smith, for example, dies with his £2 million invested, the spouse exemption broadly should apply to his UK assets and no tax is payable at that point. So, but you're right, for as long as you have the money in the UK, then there is a potential tax exposure to inheritance tax.
Yes, thanks, Charlie. Another example of how tax planning and estate planning should never be looked at in isolation. It is rare that someone wants to come to talk to us about advice and we leave them with just the tax issues in mind, because tax always has an impact on estate planning and vice versa. So, as we are now at the end of this podcast, it's probably useful to tidy up everything we've learned and discussed today. I appreciate that we've touched on a lot of different topics, each of which Charlie and I would probably say could probably merit a book in their own right. Thinking about what are those pieces of information that we want you, dear listeners, to take away and things that stay lodged in your brain. I guess I'm thinking, number one, from my perspective, please talk to your tax advisors before you think about moving to the UK. The more time you can give us, the happier we'll be. If you can give us 6 months, good. If you can give us 12 months, better. If you can give us 18 months, then I think everyone will be happy. I don't think we ever need probably more than 18 months. From an immigration perspective, Charlie, clearly there are lots of options for visas, but it sounds like if you have the funds for an investor visa, that remains the most flexible and straightforward of the options.
Absolutely. I mean, sometimes that can be the most appropriate visa category for a client because exactly as you say, it does allow them a fair degree of flexibility about what they either can or don't have to do when they're in the UK. But really, I think the message from the Home Office is that, the UK is not open for business, but we're open to attracting the brightest and the best talent to the UK. And there are various forms of visa routes, immigration categories to allow people to do that, whether it is just coming to the UK to bring their family and just live and do what they want here, or they're working for somebody, or they're setting up businesses here, or they're studying, or they're sort of global leaders or potential global leaders in various sort of important industrial sectors. We, in the budget, even in March, Rishi Sunak announced sort of a lot more sort of developments to come in UK immigration, as I say, to attract really the best and the most promising talent to the UK. So for some, that is the investor visa, but there can be, to use the expression, different ways to skin the cat. There are different routes into the UK, as always, depending on what the client's circumstances are, depending on what the client's needs and what it is they want to do, what they want to bring to the UK.
And then when we're thinking about what they want to bring to the UK, they being those clients need to think about what funds they're going to live on. And that then brings into mind the discussion we had about the remittance basis and whether actually for Americans, it actually is that tax efficient after all, not least because it's more of an administrative headache and sometimes clients are only willing to accept so much tax efficiency in light of higher accountancy costs and as a sort of, tracking their income and gains. So yet another reason to speak to your accountants, your CPAs, your IFAs, your lawyers and attorneys beforehand so that we and your US advisors can construct the best plan for you and your family and make sure that your time spent in the UK is as tax efficient and administratively convenient as possible. Otherwise, I think that is all from me. I just wanted to take the opportunity to say thank you to Charlie for lending his wisdom and experience here today. This is the first in hopefully a number of podcasts looking at US and UK tax matters. So do please look us up again in the future for further discussions on these topics. And we look forward to seeing you again.